Hello, I'm Frank Congelos. Welcome to the Institute of Responsible Wealth. Our interview today is with Alan Silk. He's a tax partner with Stark & Stark, who has offices in New York, Pennsylvania, and New Jersey. And Alan, it's a pleasure to have you here with us today. So, as always, we like to start our interviews by welcoming you. And tell us, why don't we start by you telling us just a little bit about yourself? I know that you've been practicing law and you've been a tax, expert for years, so why don't we start from there?
Unfortunately, our Bar Association doesn't permit us to use the word expert, but I started practicing with Stark & Stark in 1976. The firm was a small firm at that time. As you said, we're in 3 different states. The firm is one of the largest firms in New Jersey, and I head up our business and tax group. I've been doing this my entire career, and I just enjoy, solving the problems of individuals as well as businesses when it comes to succession planning.
Very good. As Alan, we've known each other for years, and one of the things that we always talk about is, how to protect a client, how to keep them out of court, things of that nature. And one of the things that I guess people don't realize is what are some of the issues that you see with that? And when I say that is why is it such a big deal of, okay, we never want to go to court, we want to avoid it at all costs? What is it that you're seeing?
Well, what has happened in the practice of law over the years is that litigation has really become the most expensive situation for most of our clients. If they get caught up in litigation, it could be a number that could be hundreds of thousands of dollars. This is even true in contested guardianships, not just a question of contested buy-sell agreements among shareholders or people that don't have any buy-sells, but there's situations where businesses break up, these business divorces. So litigation is the thing we're trying to avoid our clients from getting into from the transactional side. Certainly it's the most profitable area from our litigation side.
And staying with that is when we just deal with an average everyday American and so forth, I don't think they go through the course of a day thinking that they'd ever end up in court or whatever the case might be, but there's some issues as it relates to some of their personal planning that could get them there. So what are you seeing for an individual on their personal planning side that are some of the concerns or some of the areas that they need to be aware of?
Well, some of the least expensive things that people could do for themselves, which is like preparing a durable power of attorney, which would permit them to decide who is going to take care of them, when they'll be taken care of, giving those people instructions when they can't take care of themselves. And that document would prevent, in most cases, if not all cases, a knockdown, drag-out guardianship fight, where you have multiple family members that choose to get involved with, dealing with that individual's assets. And these are numbers that are not fantasy numbers when it could take hundreds of thousands of dollars and sometimes eat up almost everything that's there, and just dealing with who is going to take care of mom, dad, or whoever it may be.
My experience in just seeing some of those issues that occur over time is once you get people's feelings involved, the egos involved, and so forth, it can go on for a long time. And then there's a lot of times from a legal standpoint, I always go, when people are paid for time, there's no motivation to get anything done quick. So when we think in terms of litigation and so forth, it seems like it goes on a long time. It's not a short-term thing normally. It's like, oh, I got a problem, and it turns around quickly.
These types of litigation matters are not contingency matters. They're hourly matters. And you would hope to believe that people on both sides would want to do the right thing. But again, you're paying attorneys, and so is the other side on an hourly basis for what goes on.
So the bill's 2 times, not 1 hourly rate.
Well, it possibly is all coming out of the estate, so yes, it could be double whatever it may be, and even triple at times.
Wow. How about what else are you seeing, as far as, ways that people can protect themselves or kind of get blindsided not knowing of a document that they should have had in place?
Well, it is really shameful to believe that there are so few people that either have documents that are signed or have current documents. I mean, it's just amazing to find out such a small population that really has done any planning whatsoever. And people believe that they don't have to do planning because the government has done it for them. And the government has. I mean, if you take a look at the statutes, in fact, you don't have to take a look at the statutes. You can go to the county surrogate's office. Just look under the website for the county office and it'll show you. And they'll probably tell you what happens if you don't have a will, where your assets are going to go. It also will tell you that at the age of 18, your child or children or your grandchildren are going to get your assets if in fact they are the heirs. And that's all of your assets, and there's no protection. So what we like to talk about is, wouldn't you like to spend a small amount of money creating a will that would determine who are going to be the executors, where the assets are going, especially if it isn't as you see under the county website? Wouldn't you like to know that you don't have to pay it over to a grandchild or child at the age of 18, that you could do some planning for them? Wouldn't you like to know that if they have creditors, that those creditors, if you prepare a trust for them, will possibly never get to those assets if they have problems? And wouldn't you like to know that if they have a matrimonial case down the road, that the assets you leave to them would not be part of the matrimonial fight?
It's interesting when you say matrimonial, I always think to myself is, I catch some of the statistics that 50% of, married couples end up in divorce. So, when you mention that, and, people think in terms of, it may never happen to them, but it's like, it is what it is. It's a 50% divorce rate, and if you didn't do the proper planning, you can have a real problem.
It is very rare that we ever prepare a will or a trust that leaves any assets to a son-in-law or a daughter-in-law. Yet, in a matrimonial setting, those assets will be divided.
You mentioned the word trust, and I know that you happen to be one of the most insightful people as to how trusts work and so forth. I was careful not to mention that word expert because I know how that works. But why don't you tell us just a little bit about the benefit of maybe going the step beyond and utilizing a trust in conjunction with maybe a will or simple planning, and why it might be more beneficial to go a little extra step to get maybe what you want?
Well, Frank, think of your own situation. If you had the ability to leave to your son Frank, who's sitting over here, assets, and if you do it, he doesn't have to worry about his creditors ever coming after those assets, and he doesn't have to worry about a divorce proceeding whereby those assets could be divided up in equitable distribution, and he could be a co-trustee of that trust, determine how the monies are invested, and be able to pick another trustee to work with him, who he can, in fact, choose to eliminate at a later time and have somebody else serve, who will make some decisions that will permit the creditor protection and the matrimonial protection to exist. You sort of have your cake and you can eat it too, and it's something he can't do for himself. Not to mention the fact that from our current tax standing laws, it may never be taxed, not in his lifetime, not to his children or his spouse. I mean, it's a win-win situation.
It's interesting is when you say never be taxed, because, when you look at, our national situation, the amount of debt that we have out there and all the budgetary issues that are going on, and you look even from a state standpoint, everybody's looking for revenue somewhere. So, when we talk about, being able to do some planning, where you may be able to save some taxes, to me, then taxes become a choice. It's a choice that you do no planning and perhaps you do pay, or you do planning and you don't pay.
For most of the people we're talking about today, it's not the taxes as much as the other features that I mentioned, because whether or not we have this $5 million per individual federal credit, or we have a $1 million federal credit, the bulk of the people we're talking about are not going to fall within
Absolutely.
that type of taxable state. New Jersey, however, it's $675,000 before you can fall into a problem. So there is some planning with the trusts that can be used to eliminate some of those situations. Again, that's more advanced planning. That's not really the individuals we're talking about. It's merely the fact, why would you want an 18-year-old having funds when they really don't have the maturity to deal with them? Not saying that they won't have the maturity later on in life, but not at that time.
Right. Well, it's very similar to all the stories of people that hit the lottery, or they get a lump sum of money and then a short period of time they're broke again, or whatever the case might be, and it's because there were no constraints and no guidance on what to do.
I've lectured in front of the lottery groups nationally, and it's amazing. I didn't know it at first, but it's a statistic that is just astounding at how fast that money goes.
Very good. Alan, is there anything else that people should be doing as it relates to their planning? It sounds like, we hit on, some of the documents, and we mentioned the wills. What about, people that have documents that are in place and so forth? how often or what should they be doing with current documents?
Well, we have a policy at our firm that if people come in and see us, even before they have documents, or if they have documents, we'll sit down with them, we'll go through the documents, we'll tell them what they say, we'll do even a summary for them, and there's no charge. We'll send them an engagement letter and tell them what it's going to cost to make the changes, and they either hire us or they don't. It's hard to say. I think a rule of thumb, I would review documents certainly every 5 years. But if there's a change in the law, whatever that change may be, you have to take a look at it. Look, we live in a world where there's always change in circumstances. It's not just the law, it's our own life cycles. People are in favor or not in favor with people. There's situations where someone could have taken care of, for instance, give you a perfect example. Young people that are thinking of having children should do a will and decide who's going to be the guardian if something happens to them. Those guardianship issues change.
Sure.
Parents get older. Brothers, sisters, other relatives move out of the area, their lives change. There's all kinds of things that happen. That's the most critical thing for a young married couple. So in that situation, it's not about assets, but the guardianship of their child or future children is really critical.
Makes a lot of sense, Alan. Alan, it's really been a pleasure to have you here with us today and to discuss some of these topics. And we look forward in the future to having you on our show again. We thank all of you who have been tuned in today. We wish you the best in all that you do, and we thank you.